Right.
I must have just put one week down.
Are we ready?
I got the back.
Better show up, huh? Good afternoon. Welcome to the Tulare County Assessment Appeals Board meeting for February 15th, 2018. My name is Lance Morris. I'll be serving as chairman today. And on the panel with me today will be George Azunian and Matthew Graham, and Glenn Fowler will be serving as our alternate. To jump right into it, the first thing that I would want to talk about as part of the board comments to discuss is the possible change of the meeting dates, if we could quickly. So staff has looked into potentially changing, I understand, the dates from, or not the dates, but the actual meeting time to a Thursday morning. And that does not need to go before the board.
Board of Supervisors.
The Board of Supervisors. So we can change the meeting time into the morning if we would choose to.
Yes.
At our discretion. So I think I would like to ask the assessor's office what their preference would be. I think where it'd be still staying with a Thursday, a similar time. It's either going to be in the morning, like we used to do, or the afternoon as well. And we don't want to cause any conflicts with who's using this room and other issues too. But I'd like to ask the assessor's office what they thought would be preferable to them.
Shouldn't be a problem. What time are we talking about, generally?
It's probably would be at 9 o'clock, I would guess.
Yeah.
Yeah, 9 o'clock meeting.
That's fine with us, whatever works out.
Okay. 9 o'clock. What would be your preference, an afternoon or morning?
Actually, I believe morning's our preference, but either we could do morning or afternoon, whatever works out better for the board.
Flip a coin and we'll decide that.
Fine with us.
So I put it up to the board. What would be your preference?
Well, my preference would be 9 o'clock.
Okay.
That works out well in the sense that we get the day started and we can continue as long as necessary.
Right.
And once in a great big while, which hasn't happened in a while, we get a case that takes a while. In the afternoon, we may not have enough time to conduct all the business necessary plus hear a lengthy case.
Yeah, that was my concern as well for the afternoon meetings. Yeah. Glenn?
9 o'clock's fine with me. I'm open.
Okay. Matthew? Okay. So I think we could go with a Thursday meeting at 9 a.m. Just so we can get that on everybody's calendar. Can we move it already for next month, or we would need to keep, because we've sent out notices already, our next meeting for next month in March will be at 1:30, correct? And that's the 1:30 time. We've had a little bit of movement or change with that too. So Alyssa did say it's 1:30 next month will be our next meeting. So there's no meeting in April or May, and then our first meeting will be in June to start the new year, and we will meet at 9 a.m. Do I need a board action for that? I would think I would.
Preferably, yes.
So I'd entertain a motion to move our meeting times from Thursday afternoon to is it the second or third? The third Thursday at 9 a.m.
I make a motion that we change the meeting time for this third Thursday at 9 a.m. in the morning.
Do I have a second? Second. All those in favor signify by saying aye. Aye. Any opposed? No. That would be one exception. Will be our annual meeting, which is on a Monday still, and I believe that one is at 9 a.m. as well. And that is in July.
That's correct.
Does that sound right?
That is, July is when the assessor comes.
Right. So our July meeting is on the third Monday, I believe.
July 16th.
Okay. And that one, we would have to have a change authorized by the Board of Supervisors to change that. That's in our bylaws, so we have to keep that one on a Monday. Yeah. All other meetings would be on a Thursday at 9 a.m. Sound good? Thank you. With that, any other board comments? No? Assessor?
Sure.
Nothing? Staff? We're all good? Perfect. Let's see. With that, we'll jump into agenda item number 2, Sons of Italy. Do we have anybody here representing the Sons of Italy? We had asked them to come forward to the counter right here, to the microphone. And please state your name.
Nick Notarnicola. I'm past president of the Sons of Italy. We got the new assessments last year, and we felt they were a little bit high, so we appealed it, and we have come to a consensus with the assessors, and we'll accept his determination on the value. We're hopefully looking to maybe go to a nonprofit type of program because make it to where it's available to the public and still we can take control of it.
So my understanding, you've talked before the meeting and kind of reached a consensus?
Yes, sir.
Okay, so I don't believe we even need to swear you in at this point. So what we would do is treat your application as a withdrawal, and then the county would take care of the readjustment with you on that behalf, correct?
Yes, we could do that by rule correction.
Okay, very good. Okay. So you've met with the assessor's office already. You've come to agreement. So there's actually nothing that we need to hear before. So we appreciate you coming and doing that. So, but I will entertain a motion to accept agenda item number 2 as withdrawn.
I so make a motion to accept agenda item number 2 as withdrawn.
You have a second?
Second.
All those in favor?
Aye.
Any opposed? Thank you so much.
So thank you.
It's approved, and you'll reach an agreement later on. Thank you so much again. That was easy. We'll move right along to agenda item number 3, Blue Scope Buildings. Please come forward. And I understand we have 2 withdrawals, so we're only going to hear one item, which is agenda item number 4 on our calendar. So please state your name.
David Belpedio.
David Belpedio, thank you for being here today. We will actually ask you to be sworn in before we hear any further comments. Okay?
Okay. Do you solemnly swear or affirm that the testimony you are about to give in the matter now pending before the Assessment Appeals Board is the truth, the whole truth, and nothing but the truth?
I do.
Thank you. Please state your name for the record.
David Belpedio.
Okay, so the item we're going to hear today is application number 2016-00195. So that's the one right in the middle of our packet. And it looks like we are going to be hearing, you've already met with the assessor's office or discussed with the assessor's office in terms of determining value. You've met an agreement there, and we have withdrawals for that. So this is just dealing with a penalty
That's correct.
waiver potentially?
I do believe that we are in agreement to revise values for 2 prior years.
Okay,
Thank you.
correct. Okay.
So this is very much just about discussion about a penalty that was assessed on a business personal property filing.
Excellent. Okay. So we'll move right forward and ask you to state your case, and we can go from there.
Thank you, Mr. Chairman. Again, my name is David Belpedio, and my firm, Marks Nelson, out of Kansas City, Missouri. The client that we're representing today is Blue Scope Buildings, N.A., Incorporated, and they, too, are based out of Kansas City, Missouri. And we do a significant amount of property tax, state and local tax work for this company. It's a very important client of our firm, as are all clients of our firm. This is a situation where on a 2016 business personal property rendition that was filed, we were assessed a late penalty of 10%. And I'm here to explain to you today why I believe that this penalty should be, and ask that you please consider removing this penalty. We believe that we did file that business personal property timely, and in order to have been filed timely in accordance with your statutes, it must, in 2016, that return must have been postmarked by the next day, business day after May 7th, and given that May 7th was on a Saturday, that would have meant that that personal property return to that package should have been postmarked by May 9th. And we had written to a Mr. Roland Hill a letter that had included a copy of the actual postmark that was put on that package. And if possible, I'd like to perhaps bring this to you for your review quickly so you can look at this?
Yeah.
I don't mean to interrupt, but I believe the burden of proof remains with the assessor's office based on it being a penalty assessment. So to the extent that evidence is going to be presented through the letter, I would object at that point, as I believe it's on the assessor to properly defend the penalty assessment.
Okay, all right. So
That is correct, but assuming the assessor, well, when do we hear from the assessor and then let the gentleman?
I also have a copy of the letter for you.
okay,
It shows he
Okay, perfect.
has used Pitney Bowes instead of posted as affixed by the U.S. Postal Service.
okay. Okay, so if we could, we'll just go right into the assessor and since they have the burden of proof, and we'll hear from the assessor's office.
Thank you.
Okay,
The handout contains the letter from them, and it also has the explanation of the issue, which is, we received the statement, we stamped it the 13th. It was due to the assessor on the 9th. The letter states that U.S. postage was applied at their office on May 9th, which that's what he's saying, and provided the assessor a copy of the envelope with Pitney Bowes metered. This is not posted as affixed by the United States Postal Service. RNT Code Section 441C states, for purposes of determining the date on which the property statement is deemed filed with the assessor, the date of postmark as affixed by the U.S. Postal Service, or the date certified by bona fide private courier service shall control. So that's the issue here. Word is tax code.
so let's see. There is a copy of the actual postmark in this packet? Oh, there it is.
Yes. I mean, his date on his postmark is kind of irrelevant. It's the fact that it's a Pitney Bowes.
Yeah.
May I speak up, Mr. Chairman?
Yes.
We file thousands of returns a year, and we're very, very cognizant of appeal deadline dates and filing deadline dates, etc. And we have very good records and procedures in place, and we mail quite a few items. And the point that I am trying to make here is that we did get this in the mail properly. As to why it ended up with the 13th on it, I am not sure if it got caught up in the post office or what happened that day. My point being is that we did file that return timely. We stamped the envelope. It left our office. It was delivered to the post office along with a number of other items that day. And unfortunately, I am not sure what happened in between, and the only evidence I can provide you was the fact that it was prepared, it was put in that envelope, it was delivered to the post office, and I guess all I can do is respectfully request. This is an extremely important client of our firm. This is extremely embarrassing to our firm, to me personally. One of the reasons why I've made this trip, to request your consideration that it was properly, it was timely put in the mail. I am not sure what happened between the time that we postmarked that, took that to the post office as our person would have that day, as we always do, and why it was received on the 13th and not sooner, or why it was postmarked on the 13th and not sooner.
We've had this issue in the past.
Yes. And that was going to be my question. In the past, Mr. Assessor, you remember that a client had submitted timely a return, but it wasn't acceptable to the assessor because it was a situation where they had a lengthy property file, pages. They took the totals off of that and they stuck it onto our tax return timely. The county rejected it as being improperly put together, and the company resubmitted it correctly 2 days after the penalty. And the issue was, in effect, was there an intent to slide on the due date? And that didn't happen once, it happened twice with the same client. So this is a little different matter. And if I'm understanding this, the due date was the 10th?
The due date was the business day after the 7th. And so, given that the 7th was on a Saturday, it would have been due the 9th.
And you postmarked it to the 9th?
We postmarked it to the 9th, that's correct.
So under...
It would need to be in the mail on the 9th, is
right.
what...
So under normal circumstances, if you would have used a U.S. postage stamp and the post office would have canceled it on the 9th, there would be no issue.
We would have used U.S. Postal Service. Yes.
Right. And my question is that do you recognize, or does the, and this is for the Postal Service, do they recognize a Pitney Bowes stamp as being legal tender and acceptable to them?
I spoke with the postmaster in Visalia. She says it's human touch that does that. If it goes by on the wrong date and they don't catch it, it's still going to go out. So they don't.
You know, from my perspective, this would be the third issue that I've heard of timely file. The two of them were because it was submitted without the county standard, rejected it, they corrected it, submitted it 2 days late, and here comes the penalty. Very similar. Very similar.
Tax code's very specific, though.
Yes. I understand.
Not Pitney Bowes.
So that's my comments, Mr. Chairman.
This was mailed from Kansas City.
Yes, sir.
It would have taken at least 4 days to get here, I would guess. My question is, do you keep a log potentially in the office of the outgoing things? Obviously, we could have also had a certified mailing that would have taken care of it. Used your Pitney Bowes mailing and had everything go certified with the return receipt, and then again we wouldn't have that issue as well.
We do keep a log, and that's one of the reasons why we had a picture of this. We actually take pictures of things of items that we're mailing, and hence that's the reason why I can put that in front of you. It's a very important matter to us. Our intent was to get that in the mail, and we did get that in the mail, and I don't know what happened in between. It's our business to file timely. That's the business we're in. We don't even like waiting. In this instance, Blue Scope got us the information so late that we were at the last minute putting together their final return. Otherwise, we would have gotten it in the mail sooner. I'm not trying to blame anybody here, just talking through what actually happened.
Right. My question would be for our attorney is, because we faced this matter before as well, where we understand what happened, but based on the code, we can't even make a ruling in certain situations. Would that be one of those situations where, even though we understand what may have happened, but based on what the code says, we can't overrule that?
Actually, the under Section 463 of the Revenue and Taxation Code, your board has the ability to abate the penalty. It's a 10% penalty for failure to file on time. Assuming that he failed to file on time, and that's kind of where we're at, your board still has the right to abate that if you make certain findings. let me just read what it says. It says, if the assessee, the taxpayer, establishes to the satisfaction of the appeals board that the failure to file the property statement within the time required was due to reasonable cause and circumstances beyond the assessee's control and occurred notwithstanding the exercise of ordinary care in the absence of willful neglect, it may order the penalty abated. I'm assuming that's what you did before in the instances.
Exactly. In other words, it appeared from us in the past that the taxpayer was diligent. And in effect, by the time it got to the assessor in a form they wanted, there was a two-day gap. This sounds similar to me.
So that is within your authority. If you can make those findings, then you're in a position to abate the penalty, and the assessor will make the correction appropriately.
And I think that was the whole basis of my presentation, is absolutely no willful neglect here whatsoever.
Right. I do similar work. We use Pitney Bowes. We have a machine that puts postage on the things, outgoing mail. It dates it that day. We've had issues with the Internal Revenue Service where they're asking if it was timely filed. We provide them a proof of our mailing that day, and they accept that. I'm struggling. I don't see a willful neglect or anything like that. It went out of their machine, or it was postmarked on the 9th, which would be the due date. If it was coming from Tulare or Visalia or something like that, it definitely should have been here by the 13th. But the 13th date, from my understanding, is when you actually physically received it. So 5 days later, you received it on Friday, I guess, and that's the stamp, correct? Is when you actually received it from Kansas City.
That's correct. I mean, it all makes sense. He probably did put it in there on time. I'm not
Right.
following tax code.
Right.
If you go this route, though, I don't know where you're going to draw the line. I mean, 10 days, 5 days, I don't know.
I have I think a pertinent question of counsel. Is this similar to the indication of notice as far as somebody, let's say, exercising an option on a lease or something like that, where notice is perceived when it goes in the mailbox?
Because of the way the code is written, in this case, it's that stamped date
Right.
from the Postal Service that controls. So I think the conclusion would be yes, it's late technically. The question is whether you're satisfied that it's the circumstances are such that you should abate the penalty. Kind of debate the penalty. I think that's where you are.
I'm leaning towards abating the penalty for a couple of reasons. The Assessment Appeals Board that I've been on for a length of time always tries to give the applicant the benefit of the doubt, and that we will listen to evidence or we'll listen to issues. I remember one situation was that the applicant said that they didn't get noticed because they were doing road repairs and the garbage truck rolled over the mailbox. So the question is do you give that person the benefit of the doubt as far as timely notice? And we've tried, and this is again beyond the legal issue of kind of an issue of trying to establish reasonable policy especially on issues like this. So I'm in favor of abating the penalty.
Mr. Graham?
Yeah, I would agree with that. I mean, I think that provided there's no evidence of neglect here, and that, I think there's definitely going to be a time span between Kansas City and Tulare County, being that it's just 3-4 days. I think that, that makes perfect sense to me. And if, there's proof of it going out that day from their office, that would satisfy me to abate the penalty.
I might add to that, we've had cases that the time period was off by 15 to 30 days.
Right.
That's, to me, willful neglect.
I see Tom's point in that, where do we draw the line here?
Right.
But I don't think this is one of those cases.
further discussion?
I would suggest a motion and, of some kind then to resolve it.
I would entertain a motion for abatement.
I make a motion that we, regarding agenda item number 4, abate the penalty based upon lack of willful neglect on the taxpayer. So I would side with the taxpayer in this case.
Any further discussion?
Second on the motion.
Right. Second? All those in favor signify by saying aye. Aye. Any opposed? Motion carries. We will abate the penalty.
Thank you very much. I appreciate that.
Thank you.
The comment, if this continues to happen, I would still bring them here and.
Yes, absolutely.
Let me just say that when we have issues like that, if they are a matter of a couple of days, and there's reason to believe that, that's one matter. If it is beyond that, then you probably have the issue of willful neglect, and in effect, I would assume we would not listen to that.
Right. Yeah.
Okay.
Thank you.
Thank you.
Thank you for, hopefully you enjoyed your time in Tulare County while you're here.
It was a beautiful trip up. It really was.
To the farm show.
Yeah. Thank you. Okay. Agenda item number 5. These are non-confirmed attendance. Do we have Joseph DiNunzio here?
We've already done his, for roll correction, he was supposed to withdraw, but he never did.
Okay, so we'll hear that as a non-appear. And agenda item number 6, Rent-A-Center. Anybody from Rent-A-Center here? Same thing, you thought they were going to be here?
Well, we've spoken with them and told them they were too late to postpone. They'd have to show up in person, and they just didn't come.
Okay. So I think we will first take care of the non-appearance items, which would be agenda items number 5 and 6. And I would entertain a motion to deny those for non-appearance.
I'll make a motion to deny items number 5 and number 6 for non-appearance.
Do we have a second?
Second.
All those in favor signify by saying aye. Aye. Any opposed? Motion carries. Thank you. Then we will look at agenda item number 3. Entertain a motion to accept that as withdrawn, and the withdrawal calendar.
I make a motion to consider agenda item number 3, application 20160094, and application number 2070081, along with the withdrawal calendar as presented as withdrawals.
Do we have a second?
Second.
All those in favor? Aye.
Aye.
Any opposed? Motion carries. Thank you. And it looks like we're down to, that's it. Any further comments or information? No? With that, meeting is adjourned. Thank you so much.